Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
And welcome to Triage. I am Steve Pine, an associate in the RTP office, and I focus on healthcare regulatory and litigation issues. And I have the pleasure of being joined on the phone today by two of my healthcare colleagues, Limo Cherian, a partner in the Chicago office, and Carla Dewberry, a partner in the Seattle office. So welcome, Limo and Carla.
Hi, Steve. This is Limo, and I'm really excited to be here. My practice focuses primarily on population health and clinically integrated networks. So this is really an interesting area for us to be talking about today.
Steve, glad to join you also. This is Carla in the Seattle office, and my practice focuses on transactions and on health insurance plans that are sponsored by providers. And I'm also very excited to talk with you about this topic.
Well, welcome to both of you. And so today we're going to talk about a topic very near and dear to the heart of any healthcare regulatory lawyer, which are federal fraud and abuse laws. And when healthcare attorneys, or at least when I think about fraud and abuse, one of the first things I think about are the Stark and the anti-kickback laws. But recently we've got a new law to add to the lexicon, which is EKRA, and that stands for Eliminating Kickbacks and Recovery Act of 2018. And so this was a law that was passed a little over a year ago as part of the Support Act late in 2018. And like other fraud and abuse laws, it's a law that carries criminal penalties, and we're starting to see some litigation arise out of this law. And so Carla and Limo, could you explain a little bit about what EKRA is?
Sure. Let me start off by making a couple comments about that. So as you explained, it's a law from 2018. And like the anti-kickback statute, it prohibits knowingly and willfully soliciting or receiving remuneration, whether directly or indirectly, overtly or covertly, in cash or in kind, in return for referring a patient or patronage to three different types of facilities: a recovery home, a clinical treatment facility, or a clinical laboratory. And those terms are actually defined in the statute. A recovery home is a facility which might be referred to as a sober living facility. A clinical treatment facility is a facility which assists individuals with dealing with opioid addiction and other addiction therapies. And a clinical laboratory is generally the concept our audience is currently familiar with, a laboratory that provides lab services, as you see all over the country. So the payment or offering of remuneration is unlawful under this new body of law unless it fits within a safe harbor. And the interesting thing about this new body of law is that the safe harbors under it are different from the safe harbors that we have now become very used to under the anti-kickback statute. And specifically, one of the safe harbors that is often used under that statute is the safe harbors that deal with payments to employees or independent contractors who have a bona fide relationship with an organization. Under the new safe harbor under EKRA, the safe harbor is very, very different from what we're used to under kickback. And let me just take a second here and define what that safe harbor is. It provides that EKRA is not violated when there's a payment made to an employee or independent contractor who has a bona fide employment or contractual relationship with the employer for employment if the employee's payment is not determined by or does not vary by the number of individuals referred to a particular recovery home, clinical treatment facility, or laboratory, the number of tests or procedures performed, or the amount billed or received from those facilities in whole or in part. That's language that's materially different from what you see under the anti-kickback statute. Limo, do you want to contrast with the anti-kickback statute for us?
Absolutely. I mean, as Carla mentioned, there are a lot of similarities to the AKS, but in particular, there are a couple of exceptions that are notably distinct from the anti-kickback statute. As Carla mentioned, one of the major ones is in the context of what would be the employee safe harbor under the kickback statute. what we've traditionally come to expect as allowing all different types of compensation under the AKS, including productivity models under the employee safe harbor under the AKS, would not be permitted under the EKRA employment model. So that's a major distinction. One of the things that has sort of been interesting about the overlay and the overlap between the AKS and EKRA is there really hasn't been any guidance or amendment regarding how the two statutes play against each other. There is one provision in EKRA that specifically says that this section, specifically EKRA, does not apply to conduct that is prohibited under the AKS. But that actually doesn't address the underlying problem here, because what we're talking about specifically in, for instance, the employment exception is conduct that is permitted under the AKS and potentially prohibited under EKRA. So that isn't really addressed very well in the specific, I'd call it preemption, although it's technically not preemption, but that type of language that's in EKRA, it just doesn't cover that. Commentators, when EKRA came out, really thought that there was going to be guidance regarding EKRA and specifically its interplay with AKS. One thing to note, though, is under EKRA, the ability to propose regulatory exceptions is not given to the OIG. Rather, it's given to the Attorney General in consultation with HHS, and we just have not gotten that type of clarification. So that kind of puts us into a gray area, or what we thought was a gray area, specifically related to the overlap and the overlay between AKS and EKRA. But there's one other specific section in EKRA that I think is really particularly important for a clinically integrated network, and that relates to an EKRA exception for alternative payment models. So that exception has some very specific provisions that define what an alternative payment model is. And in the context of EKRA, that specifically means the Medicare Shared Savings Program, CMS innovation models other than a healthcare innovation award, a healthcare quality demonstration program, or a demonstration project required by law. So those are in the sort of government category. But there's one last section that's actually sort of a catch-all, which is really one of the interesting things that was in the EKRA statute that just has not been developed. Because the last possibility for alternative payment models is an alternative payment model used by a state, health insurance insurer, or group health plan, if approved by the U.S. Department of Health and Human Services as necessary for care coordination and value-based care. So that seems to imply that there's a process, or that there's a possibility to get specific alternative payment models approved by HHS. But one of the things that we've run into is that we haven't seen a process that has been promulgated for that approval.
Limo, I was going to make one other comment about the differences, just to point out that under EKRA, this body of law applies to any health care benefit program, not just federal health care programs, such as Medicare, Medicaid, and TRICARE. So for those who've thought about kickback not being applicable to their operations because they're not involved in those federal programs, they should be very aware that EKRA will now apply to the other benefit programs that they are associated with.
That's absolutely right. I mean, the commercial plans are all going to fall within EKRA. And so that alternative payment model exception would be particularly important to any sort of commercial arrangement, because unlike the AKS, this statute applies to all different types of arrangement.
And as we continue to see these evolve, one thread I think we've all seen is an increasing involvement of a focus on behavioral health and substance use disorder providers as being pulled in as part of clinically integrated networks, again, as part of the overall nationwide movement towards integrating physical and behavioral health in response to the opioid crisis and addressing things like healthcare parity. But it sounds like just like in the area of health privacy, where when you start getting into partnerships with substance use disorder providers, you need to start considering Part 2 privacy obligations. Now in the area of healthcare fraud and abuse, EKRA is raising its head as something to be keeping in mind when checking whether arrangements within the SIN are going to be compliant.
I agree, Steve. I think one of those things that SINs have to do when they start reviewing their contractual agreements is that they've been typically used to looking at them under AKS guidance, and now they really have to think about whether those arrangements are going to fall within an EKRA exception. They're going to, when they're, SINs are looking at taking on risk-sharing obligations that are based on total cost of care, and that often does include things like behavioral health and substance abuse. And the issue is that most SINs are looking at these and they understand the AKS, they're well versed in AKS, but they're just not as well versed in EKRA. So when they're looking at those types of arrangements, the question is, are they going to CMS for approval of an alternative payment model under the exception? And frankly, I don't know that there's been anything really promulgated about that process. And if there is no alternative payment model, are they actually looking to determine whether there's whether the actual requirements of EKRA are met?
So I wanted to talk for a moment about a criminal prosecution and guilty plea agreement that was recently entered into in January of 2020. And to my knowledge, this is the first publicly announced plea agreement of this sort. So let me just identify some of the facts. The facts were bad in this situation, but despite that, I think the takeaway is to understand that there will be criminal prosecutions. And so even if your facts are better than the facts I'm going to point out here, you should certainly, though, evaluate how EKRA applies to you. So this case, which resulted in the plea agreement, was entered into by a woman named Teresa Merced. First, let me say that she was an 80-year-old woman. I thought that was interesting to have a senior citizen prosecuted for this. She was the manager of a facility known as St. John Newman's Extended Hours Clinic in Kentucky. Her husband worked as a physician at that clinic, and he provided substance abuse treatment to patients. What Ms. Merced is alleged to have done, and which she has agreed that she did by signing the guilty plea, is that she received money, she negotiated and received money in exchange for referring substance abuse treatment testing to a commercial clinical laboratory. So it was your typical urine drug testing. She did this between 2018 and 2019. She had multiple conversations with the CEO of the drug testing laboratory. And in fact, at one point, she asked for a $4,000 check as a partial payment of a larger obligation to make a $14,000 check to the clinic. She had the laboratory agree to hire some professionals to work at the clinic. When she was interviewed by representatives from the Attorney General's Medicaid Fraud Control Unit, she basically disavowed any knowledge about what the check was for and indicated that it was probably something her husband had arranged for and that he was very careless with money and had probably borrowed the money from the lab's CEO to pay for an upcoming holiday vacation. She also encouraged the CEO from the lab to reply to further inquiries from the Medicaid Fraud Control Unit in a dishonest way. And so, in result of all that, she agreed that she knowingly and willfully violated EKRA and has entered into a settlement agreement. As of today, I don't believe her sentencing has been finalized, but I think this was an interesting case to be aware of because, as I said, it looks to be the first prosecution under EKRA.
That prosecution was just under EKRA. They didn't bring the government didn't bring corresponding AKS charges or anything. It was strictly EKRA.
That's right, which is also very interesting to choose this body of law to prosecute under and not to add what might have also been a crime under the anti-kickback statute.
And showing, I guess, that EKRA does have real teeth. Well, thanks very much to both of you, Limo and Carla. I think that's all the time we've got for today, but thanks everyone for listening to this episode of Triage.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.